Now, there's a couple important things that the Federal Aviation Act did not do. Number one, the Congress, when it passed the Federal Aviation Act, did not put a preemption clause. And I should talk a little bit about what federal preemption is. As all of you know, we have a Constitution. And in the Constitution, there's a supremacy clause. And the supremacy clause, in essence, says if there's a conflict between federal and state regulations in an area that the federal government is allowed to regulate, the state laws lose out. The federal law is supreme. And really, that's the basis of federal preemption. So when Congress acts, and then there becomes a conflict between state law and federal law, state law is going to lose out. Now, there's different ways that Congress can express its intent to preempt state law. The best way, and the one that makes the most sense, and the one that's easiest to apply, is Congress in the actual statute, the enabling statute. For example, here, the enabling statute that allows the FAA to issue regulations is the Federal Aviation Act. What Congress could have done, but did not do, when it passed the 1958 Federal Aviation Act, was to put in an express preemption clause. So if you read the entire Federal Aviation Act, you're not going to find anywhere in it that Congress intended that state law on safety, state law on negligence, the idea that a pilot must use reasonable care in operating his or her airplane, state law on products liability, the idea that a manufacturer of a product can't do something that is unreasonably dangerous in the design or manufacture, the failure to warn. There's nothing in the Federal Aviation Act suggesting that Congress said that's all preempted and the FAA and the federal government is going to now occupy the field of aviation safety.